Good afternoon. Good afternoon and welcome to the July regular meeting of the Buncombe County Board of Adjustment. We appreciate those who are able to join us in person and those watching online via Buncombe County media portals. We will first give everyone an opportunity to silence all their devices for the duration of the meeting. If you find yourself needing to take a call or engage in conversation above a whisper, we invite you to take those conversations outside the room. We will also remind all of those who approach a microphone to speak clearly and stay roughly 6 inches away from the mic when speaking so our system can pick you up. Lastly, members of the public wishing to participate in the hearing today have two options. One is as a party withstanding, and the other is as a witness. A party withstanding has already, before this hearing, prepared to prove they have standing as a party uniquely affected by the proposed project with credible evidence of special damages, and is prepared to present a case that includes material facts and expert opinion testimony where required, and cross-examine during the applicant's presentation. The other option is to participate as a witness, which the board may call for at the end of all presentations and just before we close the public hearing to deliberate and vote. We'll move to announcements from staff today.
So one very quick announcement, I will address the crowd. Again, please beware of fraud and scams. We've seen an increase in those. When you pay your application fee for the Board of Adjustment, this will be your only application fee until you pay for permitting. Buncombe County will never ask you to pay via gift cards or wire transfers. So please, if you see something unusual, report it to us.
Thank you for that, very helpful. Moving to a roll call of board members. We'll start with Mr. Mazelis and we'll move to staff.
Yeah, Joe Mazelis.
Paul Wazinski.
Greg Allen.
Andy Ball.
Greg Phillips.
Gabe Quisenberry.
Mark Diaz.
Dana Alley.
Savannah Glantz.
Amy Broughton. Tarana Sauter.
Thank you so much. Moving now to election of chair and vice chair. This is our first meeting of the year, this next year coming up. So I want to go ahead and conduct elections for those two positions. Are there nominations for the position of chair?
Move forth the nomination of Andy Ball for chair.
I will accept that nomination. I have several more months. I'm not sure how many on my term, and so we'll have to reshuffle after that happens this fall, winter. We'll see. Other nominations? There's a second there. Other nominations? Going once, going twice. Thank you. I'll take that as an acclamation motion then. So, all those in favor, please say aye.
Aye.
Aye. Any opposed, nay? Okay. Thank you very much. Moving to position of vice chair. On nominations for vice chair.
I'd like to nominate Craig Allen.
The nomination for Mr. Allen. Any other nominations? Going twice, three times? That's an acclamation motion. And all those in favor, please say aye.
Aye.
Aye. Any opposed, nay? Thank you. That passes. Congratulations. Thank you for your service. Thank you all very much. Moving to approval of meeting minutes. We have a set of minutes from the June regular board adjustment meeting to consider that were emailed out to board members. I believe we are 1 month off, so May. It's May, yeah. Yeah, the doubleheader, yeah. So it's May. Mm-hmm. There's a motion to accept those. Any comments, edits, questions on the minutes? Okay, there's a motion to accept. Is there a second?
Second.
All those in favor, please say aye.
Aye.
Aye. Any opposed, nay? Thank you, that passes. Moving to disclosure of ex parte communications and conflicts of interest. A member of any quasi-judicial board, a member of any board exercising quasi-judicial functions pursuant to NC general statutes shall not participate in or vote on any quasi-judicial matter in a way that would violate any person's constitutional rights to an impartial decision maker. Impermissible violations of due process include, but are not limited to, a member having a fixed opinion prior to the hearing that is not susceptible to change, an undisclosed ex parte communication, a close familial, business relationship, or other associational relationship with an affected person, or a financial interest in the outcome of the matter. With these expectations we place on board members, we ask members of the public to avoid contacting board members about the specifics of any case, past or upcoming. Board members are expected to consider all the evidence submitted by the applicant, the staff report, and supporting materials, and any admitted evidence during the hearing. This protocol keeps the process fair for all applicants and for members of the public who should expect this process to play out in a public meeting. We'll start with Mr. Mazelis.
No.
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 No. No.
Thank you very much. And as we start our public hearings portion of the agenda, before we get to our first, this hearing is a quasi-judicial evidentiary hearing, and that means that similar to a court hearing, state law sets specific procedures and rules concerning how this board must make its decisions. The board's discretion is limited. We must base our decision upon the competent, relevant, and substantial evidence in the record. Our decisions must be constrained by the standards in the zoning ordinance and based on the facts presented. For certain topics such as traffic impacts and projections about property values, this board needs to hear opinion testimony from expert witnesses. Individuals providing expert testimony must be qualified as experts and provide the factual evidence upon which they will base their expert opinion. General witness testimony is limited to facts, not opinions. If you will be speaking as a witness today, please focus on the facts and standards and not personal preference or opinion. The board can hear facts from your personal experience, but cannot consider your opinions on certain topics with the same weight as an individual who is qualified as an expert in that field and provided expert opinion testimony. Although there is somewhat of an informal nature to the proceedings today, interruptions of presentations by parties to the hearing or from the general public will not be tolerated. Members of the public may be asked to vacate the room if this becomes an issue. The board, however, may interject in order to keep the hearing on topic in an effort to keep the record to the related facts and to move along in fairness to upcoming cases on today's agenda. And with that, we have a printed agenda that you have at the front door there, but we are going to call an audible here and move ZPH 2025-00038 Carroll application up so we can consider a motion to continue, my understanding. So we'll have the applicant and the party withstanding, of course, approach and inform the board of that request.
Thank you, Chair and Commissioners. Derek Allen, I represent the applicant, Carroll at Sweeten Creek, on this SUP. We are continuing to work with the neighbor that's been granted standing and stay in regular communication with him and his professionals. We would like another month to work through concessions that we are hoping will lead to an unopposed project by the time we come back in August, and would ask this board to approve that continuance.
That's wonderful. Any statement here? Okay, agreeable to that? Okay. And is 1 month enough time, you think?
Yes.
Yeah, okay, wonderful.
Thank you.
We'll take a motion then on pushing this matter to the August regular meeting.
A motion to continue this until the August meeting.
There is a motion. Is there a second?
Second.
Hearing a motion, a second. All those in favor, please say aye.
Aye.
Any opposed, nay? That motion passes. Thank you both. That will be on our August regular meeting agenda. Moving now to our first case, ZPH 2026-00021, Transformation Village Special Use Permit Revision. We'll have Savannah Glantz up from staff to present this one.
Please state your name and raise your hand.
Savannah Glantz.
Do you swear to tell the whole truth at this hearing?
I do. Hello. I certify that this public hearing was properly noticed and all applicable parties were notified of the meeting in accordance with general statutes and county code, and I ask that all applicant and staff materials be accepted into the record as evidence.
Hearing no objections, so admitted.
Thank you. This is the review of ZPH 2026-00021, Transformation Village Special Use Permit Revision. Applicant is Timaclia of ABCCM. The property is located at 29 and 33 Allenhaven Way. The total acreage is 14.97 acres, and the development will be serviced by MSD and Public Water. This application proposes a 243-unit multifamily residential development, transitional/recovery housing facilities, an office and warehouse, as well as workforce training center, and a dog kennel. This is the application, is a major revision to a previously approved special use permit, which is ZPH 2025-00042, and this project will be within the existing ABCCM campus. This application does seek a deviation on parking. If approved by the board, staff recommends the following conditions of approval. The project must be constructed as depicted in the site plan. There will need to be proof that an updated NCDOT driveway permit and TIA has been submitted and approved by NCDOT, and the applicant must agree in writing to these conditions prior to the commencement of site work.
Okay, any questions from the board for staff at this point?
Just one question. I noticed in the application it says 351 residential units.
Correct. So some of those are going to be more functionality of like an apartment, but the other units, we don't really have a category. That's going to be the transitional recovery. That's more of like a group home situation. And the applicant can go into further detail about that.
Okay. Other comments, thoughts? Thank you so much. Before we call the applicant forward, is there anybody here wishing to assert standing on this matter? Any standing applicants? Going once, going twice, 3 times. Thank you. We'll invite the applicant forward, introduce themselves, and be sworn in.
Come on up, Scott. Scott, you come on up too. So we both get sworn in at the same time.
Please raise your right hand and state your name.
Michael Goforth.
Just go.
And Scott Rogers, Director of ABCC.
Do you swear or affirm to tell the truth at this hearing?
Yes.
Yes.
Thank you all for being here.
Thank you so much. My name is Michael Goforth with High Country Engineering. I'm the civil engineer on the project. And this is Reverend Scott Rogers, who's the executive director of ABCCM. As you know, this property has gone under one SUP already. It was done in 2015. And we are coming back to you for a revision to that SUP based on the needs of ABCCM and how their services and the services that they provide to the community have changed over the years. Plus, as we all know, construction's costs are different, some economies of scale and things like that have changed. And so that's the necessity to come before you today. We are proposing 243 units of multifamily residential development on this piece of property. They are split in different ways based on the user of them, and they kind of blend in between a group home setting, which is something that people would be a homeless shelter type setting, versus long-term care or long-term housing. So there's some different uses going on with the property, and that is why we have sort of this differential in the total unit count. I will say that I also want to point out that the office, warehouse, workforce training center will be used primarily exclusive to the residents of the property. So that is, certainly there'll be workers coming onto there, staff members coming on to do some of this workforce training and to operate some of the warehouse, but the primary folks will be people that are already residing on the property. And the dog kennel essentially is only for the residents of the buildings, the development. ABCCM has found over the years that, folks, the homeless population and their animals, their pets have become a barrier to housing. And so that is the need for building this kennel. It won't be open to the public. It's just something for the residents of the property to be used. We are asking for a variance specifically on the parking allowance. Simply, many of the residents will not have cars. It's not a traditional multifamily development that we have. Many of these folks are going to be transported to the property. They will reside on the property, and then they will be transported off the property at some point in time. So that is the specific need from the parking variance that we're asking for. Scott, if you have anything else you would like to add, I will certainly, but that is about all I have for you all today, unless you have more specific questions that I can answer on behalf of ABCCM.
A follow-up question on the transportation topic. Is the transportation you're referencing transportation that's provided via ABCMM?
Yes.
Or is it public transportation?
No, it would be provided more specifically by ABCCM.
Okay. Will the residents have reason to utilize public transportation?
I can't speak for the closest
Do you know where I'm
bus station, so I can't speak for where that is. I'm sure it could be accommodated if there's a way to do that.
Yeah, the closest bus stop is at the Petco on Brevard Road currently. The ART system is evaluating their system now. But yes, we either help folks get there or other. We either help folks get there or they walk themselves.
Thank you. Yeah, going back to the transportation issue, so is there public transportation area? Can you walk to it if need be?
Yes, there is public transportation now, and yes, a number of folks do walk there.
Okay. The other thing too, do you expect many visitors there?
So our only visitors, so the answer is no. Residents are not allowed to have visitors except on a specific request basis. The visitors are the volunteers. So one of the things that makes ABCCM unique and that really contributes to our successes, which, by the way, 9 out of 10 leave us and do not return to homelessness. And the reason for that is that they form healthy relationships with congregations of all shapes and sizes, but also with community support groups and systems, as well as rejoining the workforce.
One other question. I thought I saw in the application and everything, and maybe I'm wrong, it mentioned a dog kennel.
Yes.
Okay, can you explain that?
Yeah, so the pet kennel is specifically to overcome one of the major barriers for homeless persons is that they have a pet. Right now, and has been the case since we opened our first shelter, a major shelter at 207 Cox Avenue in 1987, has been that we find both veterinary offices and work with the various humane societies, including Brother Wolf, to temporarily house their pets. That temporary housing, in light of the fact that now folks have certified service animals and support animals, has led us down this road. We will partner with a national pet group with veterinary support just for dogs and cats who are actual pets of those residents, and have safe housing for them as well.
Okay. I'm assuming the way the weather is, there'll be some climate control areas for these.
Oh, everything we do is climate controlled.
Okay,
sir.
thank you.
Just want to get the total number of the unit count correct here. This application is for 243 units. There on the application, it talks about 351 total units on 23.83 acres. What's the total after the project is approved and built?
That is the total, the 351.
351 total.
Yes.
Thank you. Thank you.
One other point for clarification, in the application, it states the building height would most likely be 40 feet on the 64-unit structure. In the site plans, it shows the building's at 53 and 55 feet, so I just want to clarify that.
The 53 is the correct number. What's shown on the site plan is the correct building height. I'm pulling it up. Yeah, that's the correct building height.
So that would exceed the 50
Okay, then
max height.
I've got it flip-flopped.
55.
The buildings are going to be the height that the zoning ordinance allows. I want to be clear about that. I'm not. Savannah, I think that's what we've said is that they will be the height that the zoning ordinance allows.
Correct. So in EMP, the tallest it can be is 90 feet, and in CS, it can be 50 feet. So they are not asking for a deviation there. It was just a note.
Yeah, we're not asking for a deviation.
Okay. Other questions? Reverend, did you want to have a statement or anything you want to expound upon?
The only statement is that Mike is correct. This is an unusual facility in that ABCCM, the Asheville Buncombe Community Christian Ministry, is committed to achieving functional zero for homeless single women as well as moms with children. Right now, having approved the emergency shelter of 36, except for the cold winter nights that were called Code Purple, it has not been at capacity, which means we built the right size facility and units. So we're moving, as you look at the site plan, from emergency shelter, which gives us a way to find those women, single women or moms with children, a chance to stabilize and decide, are we ready and able to take the next responsible steps. Then they move to transitional housing. The transitional housing does 4 things. It moves from stability to life skills to employment skills. So they go from being unskilled workers to skilled with a professional certification by AB Tech, who is co-located. To our knowledge, we're the only homeless campus with a community college co-located on that campus. That serves not only residents, but the community. Lastly is that we allow them time to save funds and move into affordable rate housing. Now, some folks, due to disability, the fastest growing age group are single women over 60. That employment trajectory isn't the same as somebody under 60. And so we are providing the kind of permanent supportive housing with these 243 units that we're specifically talking about, so that we consider the entire continuum of care from emergency to transitional to permanent supportive housing, where some of them will live for the rest of their lives. And I hope that brief summary helps you understand the continuum of care. And what functional zero means is that we always have enough spaces so we can take anybody who is on the street that wants to come off the street. If they're ready to say yes, we're ready to say yes, and then move them through a responsible process. Where at the other end, when they leave us and exit us, and as I said, 9 out of 10 leave us and never come back. The reason we know they don't come back is we follow up with professional case managers for 2 years after they leave us. So not coming back is not a made-up number in 3 months or 6 months. It's really showing a pattern of stability, sobriety, and success. Thank you.
Wonderful, wonderful. Other comments, questions, thoughts?
I think it's a well-thought-out project.
I think so. Much needed resource in the community. Anyone here to speak as a witness on this matter? Any call for witnesses? Calling twice, 3 times? Thank you. Anything in closing you want to
No, thank
say?
you. Thank you for your time today.
Wonderful. Thank you both. We'll close the public hearing and open up for board discussion and deliberation.
I echo Gabe's comments, well-thought-out plan, and the community should be very, very appreciative of this organization. Thank you.
Thank you. Okay, ready for a motion whenever you all are.
Mr. Chair, based on the evidence presented to this board, including the following exhibits: the petitioner's application, the submitted development plan, the GIS maps, the staff report, testimony presented at the hearing, I've moved that this board adopt the following findings of fact: that the matter was properly advertised, is within the board's jurisdiction, and is ripe for its consideration; that this application, together with the conditions proposed by staff and/or this board and agreed to by the applicant, if any, does meet the requirement for granting a special use permit contained in the Buncombe County Code of Ordinances, Section 78-321, Paragraph 3.
There's been an approval motion. Is there a second?
Second.
All those in favor, please say aye. Aye. Any opposed, nay? That passes.
Mr. Chair, based upon the foregoing findings of fact and for reasons set forth therein, I move that the requested special use permit be approved and that the order approving the permit be adopted and executed as presented and as modified in this meeting.
Is there a second?
Second.
All those in favor, please say aye.
Aye.
Any opposed, nay? Thank you, that passes. And at this point in time, we'll call staff for an order on this project.
Having considered the evidence presented to this board, including the application, the submitted development plan, the GIS maps, the staff report, the testimony presented, and the arguments, the board makes the following findings of fact. This matter was properly noticed and advertised, and it is within the board's jurisdiction and ripe for its consideration. That the applicant applied for a special use permit to modify an approved planned unit development for a 243 multifamily residential development transitional recovery housing facility, including office, warehouse, workforce training center, and kennel on 29 and 33 Olin Haven Way. That the property is located in a commercial service and employment zoning district. At the hearing, the applicant and any parties withstanding were given the opportunity to offer oral and documentary evidence, as well as to submit questions to each other, county staff, and board members. Pursuant to Buncombe County Code of Ordinances, the board finds as follows with respect to the special use permit. That the land within the PUD will be under single ownership or management by the applications before final approval or construction, or have proper assurances, proper assurances have been provided such that the development can be successfully completed by the applicant. The density is consistent with the intent of the district in which it is located and conforms to that permitted in the district in which the development is located. The land uses are compatible with and do not violate the intent of the zoning district and do not disrupt the character of the community. The proposed land use meets minimum requirements for land development as follows. The minimum lot size and requirements for interior setbacks preserve the spirit and intent of this section and comply with the density requirements for the zoning district. Proposed heights set forth in the application comply with the spirit and intent of this section with respect to the total development plan. The board finds that the minimum distance between buildings will ensure adequate air, light, privacy, and space for emergency vehicles. The development provides reasonable visual and acoustical privacy for all dwelling units. Fences, insulation, walks, barriers, and landscaping will be used for the protection and aesthetic enhancement of the property and the privacy of its occupants, screening of objectionable views or uses, and reduction of noise. Multi-level buildings are located in such a way as to dissipate any adverse impact on adjoining low-rise buildings and do not invade the privacy of occupants of such low-rise buildings. The structures located on the perimeter of the development will be set back from property lines and rights of way abutting streets in accordance with the provisions of the zoning ordinance. This board finds that the proposed parking complies with the spirit and intent of this section. As applicable, this board finds that the conveyance and maintenance of open space, recreational areas, and community-owned facilities are in accordance with North Carolina general statutes, specifically the Unit Ownership Act, and any other appropriate mechanisms as specified. The board finds that the building envelopes shown in the submitted plans depict the maximum expanse of the proposed footprint of the structure. That pursuant to the Buncombe County zoning ordinance, satisfactory provision and arrangements have been made for the following. The proposed use will not adversely affect the health or safety of persons residing or working in the neighborhood. The proposed use will not be detrimental to the public welfare or injurious to property or public improvements. The proposed use will not cause or have adverse effects on surrounding properties due to noise, vibration, odor, or glare effects. Satisfactory ingress and egress for the proposed use of the property and proposed structures has been provided. Provision of off-street parking and loading areas where required have been arranged for. Provisions for adequate and proper utilities with reference to locations, availability, and compatibility have been arranged for. Provision of buffering, if deemed necessary, with reference to type, location, and dimensions have been arranged for. Signs, if any, and proposed exterior lighting with reference to glare, traffic safety, economic effect, and compatibility are in harmony with properties in the district. Playgrounds, open spaces, yards, landscaping, access ways, and pedestrian ways have been arranged for. Buildings and structures with reference to location, size, and use are acceptable. Hours of operation are acceptable. The standard conditions will apply with one following addition. The applicant must provide proof that an updated NCDOT driveway permit and traffic impact analysis has been submitted and approved by the NCDOT. The applicant must agree in writing to the standard conditions as well as the one I just stated. Based on the foregoing findings of fact, the board makes the following conclusions of law. The applicant's request for a special use permit, together with the imposition of the conditions found necessary, which are incorporated herein as if fully set forth, meets each applicable requirement of the Buncombe County zoning ordinance. Now, therefore, based on the foregoing findings of fact and conclusions of law, the Buncombe County Board of Adjustment orders that the applicant is hereby granted a special use permit to establish a planned unit development on the property as requested, subject to the conditions referenced above, which are incorporated herein. July 8th, 2026.
Order has been presented. Any questions or comments on that? Is there a motion?
Motion to approve?
Is there a second?
Second.
There's a motion and a second. All those in favor, please say aye.
Aye.
Any opposed, nay? That passes. Thank you so much. Thank you. Congratulations. Mhm. Moving straight into ZPH 2026, 00026, the Villas at Haywood Variance. We have Savannah Glantz to present that one.
Good afternoon again. I certify that this public hearing was properly noticed and all applicable parties were notified of the meeting in accordance with the general statutes and county code, and I ask that all applicant and staff materials be accepted into the record as evidence.
Hearing no objection, so admitted.
Thank you. This is the review of ZPH 2026-00026. Applicant is Stephen Drake of Villas at Haywood LLC. Property is located at 1925 Old Haywood Road, and the total acreage is 1.83 acres. The property is serviced by sewer and water, Applicant is seeking a reduction in the rear yard setback from 10 to 6.5 feet. This is a unique case. The applicant received approval for a 52-unit affordable housing project on this parcel in 2023. That's ZPH 2023-00008. During planning and board review, it was overlooked that a retaining wall exceeding 10 feet in height, which meets the definition of a structure per the Buncombe County zoning ordinance, was placed within a setback, and as such, the applicant is seeking a variance for just the retaining wall that was on the originally approved site plan back in 2023.
Comments, questions for staff on this one?
Just for clarity, the only thing that's changed is the request for the retaining wall? For the
Correct.
positioning of the retaining wall?
So not positioning, so back in 2023, it's the exact same site plan that's before you today, the exact same retaining wall. It was just at the original review in 2023, it was not caught by anyone at the time that this wall would exceed what's allowed in the setback. So per the conditions that you usually see master site plan permit approval and submittal, when they submitted for the master site plan permit recently, it was then discovered that that retaining wall was over 10 feet, is within the setback, so now they're simply asking for a variance for that.
Thank you.
Joel?
Has a retaining wall been built?
No.
Okay.
Thank you so much. Is anyone here today wishing to assert standing in this matter? Any standing applicants? No? Okay, we're all set. If y'all come forward. Call the applicant.
Please state your name and raise your right hand.
Stephen Drake.
Jeff McCluskey?
Do you swear or affirm to tell the truth at this meeting?
I do.
I do.
Thank you.
Thanks for being here today. Welcome.
Hey, good afternoon to the Board of Adjustment. So, as I said, my name's Stephen Drake. I'm a tax credit developer. I'm also a general contractor.
Excuse me just for a second. Could you speak closer to the microphone, please?
Oh, yeah, sorry. Sorry about that. So, my name is Stephen Drake, and I work with WDT Development and Broadcraft Construction Company. Both of these companies specialize in providing affordable housing in North Carolina. Our typical product is a senior development, and in this case, the villas at Haywood, this is a senior development. I think Savannah covered it well with what happened. We originally applied for this special use permit and had our civil engineer, Jeff McCluskey, had located it, shown it within a setback, and presented it as such, and it was approved, and we moved along. And 2023, we did not receive a tax credit allocation. It's very difficult to get tax credit funding, but we were able to do so in 2025. So as soon as we received the allocation, it's pretty much, we hit the ground running. We started civil design, architectural design, and got to a point here within the last several weeks where we'd completed the civil work and architectural work and submitted the civil drawings for the site plan review process. So we did that, and this is when we encountered the issue that the retaining wall was needing to be set outside of the 15-foot setback. But this presents a significant problem, and that's why I'm here today requesting this variance. It's going to be incredibly burdensome to move this wall. In fact, it's really a deal killer for this. This is a very tight site. It's triangular in shape. Parking is restricted. The building elements are restricted. And if we have to move that wall outside of the 15-foot setback, the result is going to be a reduction in parking of 7 spaces, and effectively it'll eliminate 5 apartment units. I think the application says 4, but it'll be 5 apartment units from this community. So the result is that we'd have to redo the civil drawings because this wall will change parking, it'll change stormwater structure, the design of the stormwater detention system, and also the building. The building's going to change as well. And it's just no easy fix at all. This will take, in excess of $100,000 to redesign. And even a bigger problem is that it'll take several months to do this redesign. And we're at a pinch point with time, and time is of the essence for these projects. And we have a July 31st closing scheduled. So we need to meet this deadline and be able to close, but in order to be able to close, we have to make it through the site plan review process so we can get our building permit afterwards, after, of course, their review as well. If we cannot make that deadline, we'll have significant problems with financing. Right now, we're locked in with very favorable rates for our permanent mortgage. Also, we have very favorable tax credit pricing. This is an affordable housing community. The major component of financing is tax credits. And currently, right now, we're able to sell those at 82 cents. And the market is 77 to 78 cents, which really only sounds like 4 or 5 cents. But this essentially equates to about $500,000 to $600,000 in funding gap. And this is just not going to work. It's going to blow this deal up. It's something that, we've been working on as a development team, since really essentially 2022. And Buncombe County needs affordable housing, especially senior housing. And we'd very much like to deliver this product, but we really must have this variance approved. Otherwise, this project will not come to fruition. I think that, this is a great thing for Buncombe County, and I hope that the board sees it as a benefit and allows this variance to occur. grants us this variance, and would appreciate your support in the matter.
Remind us on the unit split, what percentage of AMI will these be set at?
So there's a great deal of 30% units, so we have 30, 50, and 60, I believe.
Okay. And I'm looking at the maps here and the site plan. Do you have a schematic on the retaining wall or how it'll be visible on the property? I know it's abutting this adjacent property, not the
I
road.
think we presented one back in 2023. I do recall Ross Deckard providing, our architect actually produced a color rendering of the wall. The property adjacent to it, which I believe is the,
It won't be visible.
yeah.
So,
Yeah.
so basically, the way that the wall is set up is it's actually holding back our site from the adjacent property, which is below us, which is the, was it Hawthorne at Haywood apartment complex.
Okay.
So to kind of clarify, we'll have our parking lot, we'll have our 20-foot wall, and then it basically goes into, there's I think a buffer and a creek, and then the stormwater management for Hawthorne at Haywood. And their closest building is actually 280 feet away, which is their clubhouse office complex building, which actually has roughly a 20-foot wall there, and they're actually situated above our site. So from a visibility standpoint and from a safety standpoint, there is no structure that if this wall were to collapse, as if there was a concern about that would be impacted. From a visibility standpoint, there's, like I said, 280 feet from this wall to the next near structure. And then, like I said, visually from Old Haywood Road, you're not even going to notice it because our parking lot, and then we'll have our shrubs and our landscaping at the top of the wall. So that's part of the issue that we have is for us to basically take the wall where it's proposed in the middle of the setback and then bring it out of the setback. Essentially, we would have no landscaping room to put at the top of the wall at the edge of our parking spaces. So that is one of the other concerns, plus the concern of having a parking stall at the very edge of a 20-foot retaining wall.
Okay. Yes, Joel.
Yeah, the facilities on the other side of your wall, have they brought up this issue with the wall that you plan to put up, or any communication?
We haven't had any communication with them, but, of course, there was notification, placed on the property, and I assume that, neighboring properties were probably notified. But certainly the variance assigned, stating that there was a variance request was posted on the property.
Thank you.
Other thoughts, other questions? Anyone here as a member of the public wanted to speak as a witness on this one? Any witnesses? Thank you. Anything in closing you wanted to wrap up with?
No, sir.
Okay, sounds good. Thanks for being here. We'll close the public hearing and open up for board discussion and deliberation.
To me, it sounds like minimal impact to allowing it to stay in the setback. I don't see any big issues with it. There's going to be no high visibility of it. It's up against the stream, I guess, so.
I agree with Mark. It's just the location of the property is conducive to this adjustment, meaning there's just watershed behind. The other property on the other side has a corresponding wall of comparable size. It's not visible to the public. If there is one, in my opinion, for an exception, this is it.
I agree with that.
Yeah, since this project was approved earlier, and there was an oversight going back, at least 3 years, I don't think the applicant should suffer because of that. You know, not that we, and this has come before us, before a case where someone didn't do their job properly. So, you know, I support it.
Right. Sounds good.
Mr. Chair, based upon the evidence presented to this board, including the following exhibits, the petitioner's application, the submitted site plan, the GIS maps, the staff report, testimony presented at the hearing, I move that this board adopt the following findings of fact. Number one, that this matter was properly advertised, is within this board's jurisdiction, and is right for its consideration. Number two, that this application, together with the conditions presented by staff and/or this board and agreed to by the applicant, if any, does meet the requirements for granting a variance contained in the Buncombe County Code of Ordinances, Section 78-621, subparagraph 4.
There's been a motion on findings of fact. Is there a second?
Second.
Hearing a motion and a second, all those in favor, please say aye.
Aye.
Any opposed, nay? That passes.
Mr. Chair, based on the foregoing findings of fact and for the reasons set forth therein, I move that the requested variance be approved and that staff be instructed to draft an ordinance or an order consistent with this motion approving the permit with any agreed-upon conditions for review and execution by the chair, acting chair, or such person's designee on behalf of this board.
There's been an approval motion. Is there a second?
Second.
Hearing a motion and a second, all those in favor, please say aye.
Aye.
Aye. Any opposed, nay? That passes. Thank you all so much. We have an order to present on this one.
Having considered the evidence presented to this board, including the application, the submitted development plan, the GIS maps, the staff report, the testimony presented, and the arguments advanced by the parties, the board hereby finds facts as follows. This matter was properly noticed and advertised, is within the board's jurisdiction, and is ripe for its consideration. That all required notices were sent, proper signage was posted at the property, and sufficient legal advertisements were published. That the applicant applied for a variance to the zoning ordinance of Buncombe County for a reduction to the rear yard setback for an accessory structure, specifically a retaining wall, within a planned unit development. The property is located in the R2 residential zoning district. That at the hearing, the applicant and any parties withstanding were given the opportunity to offer oral and documentary evidence, as well as to submit questions to each other, the county staff, and board members. That an unnecessary hardship would result from the strict application of the zoning ordinance of Buncombe County, that the hardship does result from conditions that are peculiar to the property. The hardship did not result from actions taken by the applicant or the property owner. The requested variance is consistent with the spirit, purpose, and intent of the ordinance, such that public safety is secured and substantial justice would be achieved by granting the same. Based on the foregoing findings of fact, the board hereby makes the following conclusions of law. The application, together with any conditions referenced above, which there were none, satisfies the requirements for granting the variance contained in the Buncombe County zoning ordinance. Based on the foregoing findings of fact and conclusions of law, the Buncombe County Board of Adjustment orders as follows, that the applicant's request for a variance from the zoning ordinance of Buncombe County is hereby granted. July 8th, 2026.
There's been an order presented to the board. Any questions, comments, or a motion?
Motion to approve?
There's a motion to approve. Is there a second?
Second.
All those in favor, please say aye.
Aye.
Any opposed, nay? That passes. Thank you. Congratulations. We will call a 5-minute recess. go ahead and come back to order and proceed to ZPH 2026-00005, White Oak Town Special Use Permit. This was a case that's continued from the June regular meeting, and we have Jason Payne with us. And we'll swear Jason in.
State your name and raise your right hand.
Jason Payne.
Do you swear or affirm to tell the truth at this hearing?
I do. All right, I certify that this public hearing was properly noticed and all applicable parties were notified of the meeting in accordance with general statutes and county code. I ask that all applicant and staff materials be accepted into the record as evidence.
Seeing no objections, so admitted.
This is the review of ZPH 2026-00005, White Oak Towns. The applicant is Hannah Dame of D.R. Horton. The owner is the Ethel M. White Life Estate. The property is located at 260 Christ School Road. It is 3.88 acres, serviced by public MSD sewer and City of Asheville water. Property zoned R3. The applicant has applied for a subdivision plan unit development 1 to construct a 44-unit townhome development. For the sake of transparency for both the board and members of the public, this property is currently in violation of the Buncombe County Erosion Control Ordinance for land disturbance over an acre with no erosion control permit. As we know, the Buncombe County zoning ordinance waives PUDs from standard dimensional and parking requirements, so this project is seeking the following deviations. Because these are townhome lots, they are seeking a reduction in lot size from the required 6,000 square feet to a minimum of 1,320 square feet. Interior setbacks and building separation would be reduced to 0 feet in order to accommodate those shared walls. And asking for a parking reduction of 2 spaces per dwelling unit to 1.3 spaces per unit. Buncombe County recommends the following conditions. A major subdivision plat must be submitted, approved, recorded, and new pins assigned and reflected in the Buncombe County GIS prior to site plan review applications. A North Carolina Department of Transportation permit would be required. An erosion control permit must be issued prior to any site work being performed on the site. Remediation of the existing erosion control violation will be performed through the erosion control permit, and the project must be constructed as depicted in the site plan. Does anyone have any questions?
Thank you. Can you give us the second adjustment they're requesting, the reduction for the lot sizes?
Yes, so interior setbacks and building separation would both be reduced from the typical side setback of 7 feet to 0 feet in order to accommodate those townhome lots with the shared walls, and also building separation for the same reason. Kind of by definition, those would need to be reduced to 0 feet in townhome lots.
Thank you. What was the parking requirement before the reduction proposal to 1.3?
The parking standard is 2.0 in a subdivision.
Thank you so much.
And the erosion control issue, that is with the current landowner, which is not the applicant?
You are correct. The current owner is the Life Estate of Ethel M. White. They are currently the holders of the violation.
Okay, thank you.
Any board questions? Thank you so much.
Thank you.
Yeah. Anyone here wishing to assert standing in this matter? We have 1 hand, 2 hands. Okay. Anybody signed up in advance to run a?
There are a lot of pre-applications for standing. I'm
Okay.
not sure which is going first.
Sure. And how many do you have?
9.
That was 9?
Yeah.
Okay. And we had a raise of hands over there with the couple, I think. And were you the only 2 in the room that wanted to assert standing today? Anybody else? Oh, sorry, 3?
I will address.
Yeah, please do.
I will address the board because we addressed them last time with the 9 individuals who I was representing.
We did, that's right. Okay. So let's do that first and then we'll call you up there. Yes, sir. Let's go ahead.
Good afternoon, board. Mr. Chairman, I had represented, I think, the majority, if not all of the members who sought standing at the last hearing.
Okay.
The applicant agreed to continue until this day to see if we could come to an agreement as far as conditions to mitigate the effect of this project on my clients we're seeking standing. We have come to that agreement.
Excuse me, can you talk into your mic? Appreciate it.
It may not be on, if you'll check that real quick.
Do you want me to start all over again, Mr. Mazelis?
Yes.
So, good afternoon, Board. Mr. Chairman, Brian Golden, I think I represented most, if not all, of the non-members who sought standing at the last hearing. We did not put on any additional evidence for standing because the applicant agreed to continue this SUP until today's date so that we could attempt to work out some conditions that would mitigate the effect this special use permit might have on the individuals that I represented, those 9 with standing. We have done that, and so at this time, none of the, and I'm not sure who else, but all of the individuals that prior to last month's hearing had sought standing, we are no longer seeking standing because there's an agreement for conditions that will be imposed with the applicant's agreement. So for us, there are none.
Okay. And how many standing applicants do you currently represent today? Is it 9 still?
I'd have to look at the names. I do not represent the 2 individuals that raised their hand, but I've got 2 here today, and then the other ones. And I'm happy to get the board a list of the clients, but it looks like it's about 6 out of the 9.
Okay. And Mr. Freeman, is that your understanding as well?
Yes, Mr. Chair, it is.
Perfect. So at this time, we'll call up one of the 2 or both and swear you in and talk about standing. And it'll be this dais up here at the top.
Please state your name and raise your right hand.
Douglas, Douglas Fraser.
Do you swear or affirm to tell the truth at this hearing?
I do.
And just to clarify, are you and your wife separately going to be giving your testimony?
Yes, if that is allowable.
Oh, no, of course. I just wanted to know what to put down. Thank you.
Okay.
Thank you, sir. Thanks for being here.
Well,
And,
thank you.
We're going to deal with just not the comments about the case or your view of it or anything, but your petition on standing and why you think you have standing in this matter to be a participant in the hearing.
Yes, pardon me. My wife and I bought our property in what's called Tall Pines Trail in November of 2021. And in January of 2024, okay, I should stop and say we have Pinner Creek running through the front of our property. The back butts up to 248 Christ School Road and is forest. And also in the front of our property is another unnamed creek that joins with Pinner Creek right below, right downstream of our driveway. In January of 2024, we noticed a substantial increase in the amount of runoff that was going through the creek. In July of 2024, with a local rainfall event, not with Hurricane Helene, there was enough runoff to cause the water to back up, flood the banks of the creek, which are 4 to 5 feet high, flow all the way around our house, and threaten to take the moorings out from underneath part of the house. The runoff that is now coming through the creek has, as of that time, has been marked by red sediment, and there is also red sediment, red water coming through the forest between us and 260 Christ School Road.
You say red water, you mean?
I mean
iron-
water
iron or
that
rust?
is opaque due to red clay being suspended in it.
Okay.
That kind of water does not originate on land that has vegetation on it. It originates from bare soil. And the bare soil that is upstream of us is on 260 Christ School Road. We have photographs that can document this. I've got a degree in agronomy, another degree in soil science. I'm familiar with the problems of sloping soil and of erosion. The North Carolina Department of Environmental Quality says that rain that falls on land in fair condition without a perfect lawn sheds about 49% of the water that falls on it as runoff. For concrete or asphalt, that's 98%. Given that we are already having a huge problem with runoff caused by the violations that have been mentioned here, we can only expect that to get worse if part of that land is put in under asphalt and roof and concrete.
How far are you from the property? How far does your property lie from 260 Christ School Road?
We have one lot between us and it. 260 Christ School Road empties into Pinner Creek and also through the forest to our property.
Are there other properties that neighbor your property that also touch this creek?
That touch the creek, let's see, yes, there are two others. The water that is coming in there, in one case, has destroyed a culvert, but it has not threatened their house, and so they have not petitioned for standing. They could provide evidence if you wish.
And what is it that's unique about your property that would cause damages, do you expect, from this proposed project that would be unique or separate, different from other neighbors in your area?
What is unique to it is its low-lying condition along Pinner Creek and the fact that the runoff has worsened since we bought the property.
In general, not due to not due to activities on 260 Christ School?
Very definitely due to activity on 260 Christ School Road.
Okay.
We saw a significant increase in runoff in January of 2024.
That was from that property?
Yes,
You suspect?
yes, and we've got photographs that can show that.
Board questions?
I have a question. And maybe this would go to staff. That erosion violation, is it connected at all with what he just said about problems in the area?
I'm not an erosion control officer, so I cannot attest definitively to that professionally. But there is a erosion control violation on this parcel. I mean, the parcel has essentially been clear-cut without any sort of permitting or any sort of erosion control standards. So I will just leave it at that and say that. But that would be the, again, just the state of the property as it is right now.
Mr. Fraser, do you have any exhibits to show specifically where your property is in relationship to the applicant's?
I could find that quickly. I can show you photographs of the water that has come through our property due to this development or due to this clear cutting. We have a plat map available on my computer.
Yeah, I'm just trying to get a sense of where you are on the map in conjunction with it's very easy to find the applicants because it is clear cut. But
Yes.
the rest of it's very heavily wooded, and so I can't see where you're located.
So we'll call you up in a minute to do this again with you, ma'am, if you will. Thank you for the offer.
All right, sir, what is your address?
14 Tall Pines Trail in Arden.
Maybe you can identify it on the map.
So according to the GIS measurements, it is approximately 575 feet away from the closest point to the subject property.
Thank you, Jason.
Mr. Ball, I do appreciate that it is not immediately adjacent, but the runoff from that property is very heavily impacting ours.
It just appears on the map to us that the Penner's Creek is running through a property owned by Reynolds Trust and is not quite reaching your property. Is this a stream, a tributary to Penner's Creek that you're talking about in your backyard?
No, sir. It is, as far as we can tell, it is Pinner Creek. And as far as we can tell, the map is inaccurate in locating the waterway at present in history.
It does run across your property, though.
Yes,
Okay.
very definitely. We have frequently walked along Christ School Road between our property and Coventry Woods, and we see where the creek comes down from in front of 260, joins another part of the creek that runs underneath the road, and then continues on and runs through our property.
Okay. Are there board questions or ready to talk about it?
If you were to be granted position with standing, what are you prepared to present other than your personal experiences?
We have not had time to consult with a hydrological engineer. I teach part of the time at Payap University in Thailand, and we were in Thailand when the first hearing was held. We sent a document for the board, but given the fact that we were not able to be physically present, that was not accepted. Had we been able to present that, we might also have consulted with the people in Coventry Woods and been able to arrange something cooperatively with them. But we returned here 2 weeks ago, this coming Friday, and I'm sorry we have not had the opportunity to present any kind of professional evidence.
But you would be prepared or would not be prepared to do so if you were granted standing?
It depends upon the length of time that we would have.
If you were granted the time to do so, you're prepared to do that?
Within reason, yes, sir. We do not know what it would cost us as two private individuals to hire a hydrological engineer. I do know from my slight understanding of the calculations that are available online that even if we allowed that 51% of the water is absorbed into the soil, it would still take a retention pond 10 feet deep and 49 feet in diameter to contain the water from a 1-hour storm using the 25-year figures for Buncombe County. It's a substantial problem, and it's only going to get worse if the soil is covered up.
Okay, I think we might be ready to roll on this. Yes, please.
We would like to be heard and
an opportunity to rebut some of the things that were said. We're happy to do that before the board
Yeah,
deliberates or whenever you believe it's
do that
appropriate.
before we deliberate.
So, I looked at Mr. Frazier's standing application. I don't know if the board had an opportunity to do that. He did have an attachment with that standing application, and he highlights some of the same stuff that he mentioned in his testimony: water runoff, sediment load, and he talks about traffic as well. The board, we've talked about what you have to show to get standing in one of these procedures, in one of these proceedings, and it's a credible allegation of special damages that rise beyond the level of speculation. So first, let me pan back and talk about the state of the property now. As Mr. Payne made clear in his presentation, that was not the applicant. The applicant did not clear cut that property. That property, you can tell from GIS, it has been clear cut, and it's red on GIS. The testimony you heard from Mr. Frazier is that red water, he sees it coming off of the property. So I think something that I haven't had an opportunity to talk to Mr. Frazier. I didn't know that he wasn't represented, but I do want to talk to Mr. Frazier, and I think that some of the things that we can explain may relieve his concerns, and I want to tell some of them to the board as well while I've got you both here. So the current state of the property is objectively not good, and that water is hitting the property, and it is going into red clay, which does not absorb much water, and it is flowing whatever the natural course is. If this development is built, it will be required to have a sophisticated stormwater management system built to the standards of the Buncombe County Stormwater Control Ordinance. What that means is the calculation, and I'm not going to hazard as to whether his calculations are correct. That's the kind of stuff that requires experts. We've got Mr. Sugg to talk about that here today. But you can see on our site plans that there are some storm tech detention devices that are going to take that water and detain it on the property and then slowly release it after it's been treated, and that sediment can leave the property. So that problem you're seeing of this red water, this development would fix that. So I think that it's speculative, and I think it's probably incorrect to think that the development of this property as submitted in our application would make things worse. It's probably going to make things better, right? That water that is untreated now is going to be treated and improved and detained and slowed down as it releases. And that should be a good thing. From a technical standpoint, I think that means that Mr. Frazier has not made a credible allegation of standing.
Objection.
If you will let him finish, yeah.
From a practical standpoint, I think that it should give some comfort on the stormwater component. I'm sorry.
My point is that the issue of stormwater damage versus sedimentation damage are two different issues. With simple check dams, a lot of the sediment can be made to drop out of the water as it is carried along. That's good for trout and other animals that are in the water, but it does not reduce the amount of runoff that is going downstream. That is a different issue, and I do not know that from our check of the site plan, the size of the retention area does not seem adequate to protect against water erosion, merely against the flow of sediment. Those are two different issues, and we would very much like to have somebody review that, and there has not been opportunity, and we would like that review to happen before the plan is approved.
Mr. Freeman.
I think that what we have here today is an opportunity for Mr. Sugg to be here, and while we object to Mr. Frazier's we disagree that he has standing and participate as a party. We have no objection to him asking Mr. Sugg questions and getting those answers, because I can assure you that the Buncombe County Stormwater Ordinance requires both. It's not just sediment control, that's the erosion control ordinance. It also requires proper stormwater management. And, there's little that can be done about the amount of raindrops that fall on a particular parcel. But in these developments, the way they are designed is so those raindrops are treated in such a way that it's like they go through a natural process, and it's going to be better than when they hit red clay. So the amount of water, that is in the hands of the Almighty, not us. But how the water is treated is the business of Mr. Sugg, and he's going to be able to explain that and explain. So the stormwater ponds you see on the plan are not the end of the story. There are other measures that are on that site plan, and Mr. Sugg can walk you through that. And again, we're happy to let him, to have him answer any questions Mr. Frazier has.
Okay, at this time, we'll have board discussion, deliberation.
May I ask that my wife also be given the opportunity?
After you, yes.
Thank you.
We'll open up for discussion.
Yeah, I'm still kind of in the dark. Are we talking about this topic of an erosion violation? We don't know what that is. The other thing, too, counsel for the applicant said there's going to be things done to correct the problems.
We're just talking about standing. This is a standing.
Yeah.
Yeah, so none of that applies.
To me, I don't have the information to make a clear-cut choice on this.
Well, it seems, so to help the board a little bit, I think that it's on the applicant to prove their standing criteria. And if they haven't proved that, that's an easy call to make then. So is there an element is there a standing related question you had that wasn't answered, or?
Yeah, Mr. Frazier, I'd like him at the opportunity, because of the circumstances he was out of the country, to allow him to bring in some experts. And
If he has standing.
what's that?
If he's found to have standing by the board.
And that would be
That's the second question, yeah.
Yeah, and that would be the opportunity, because, I always feel let's hear from the experts.
Right. Other thoughts? Yes.
This may be more of an observation, but counsel for the applicant said, on one hand, he objects to Mr. Frazier getting standing, and on the other hand, he's willing for him to be able to ask Mr. Suggs questions. And the only mechanism that I know of for that is for him to have standing.
Technically, yes.
So in a kind of a roundabout way, he seems to be saying, sure, give him standing, although he says he's not saying that.
As we know later on in the process, if the applicant for standing would stick around, we have a witness process where they can not ask questions back and forth, but to express concerns during that time. And the applicant then has, or their rep has an opportunity after that to go through and respond to anything, not a Q&A directly, but airing of grievances.
And Mr. Chair, I would like to point out that it's a very technical thing. When a party is granted standing, it is a big deal in the legal process. So there are implications that would have an impact on proceedings after this Board of Adjustment hearing. So that's why we cannot consent to standing, but we can allow, as a practical matter, for participation to occur, but we cannot agree that this party has standing. And again, the big question here is, are there special damages? And are the damages that they claim to have suffered, are they unique to their property? There's been no showing of that uniqueness. The damages they're talking about would be the same to all the properties in the area and the properties along that creek. I think I also have to point out that he's disagreeing with the location of the creek. I think that people sometimes will say, creek locations on GIS aren't always perfect, but when you adjust those lines, it requires the involvement of expert testimony, surveyors, NC DEQ. So, I think that we can rely on GIS for the vague location of that creek.
So I would say I'm right sort of in the middle on this one, just because we've got neighbors that are also impacted along this same creek. So that extinguishes for me the idea that he's in a unique location. On the other side of that coin, though, there's a lower lying lot, apparently. The applicants testified to a lower lying lot. And does that cross the threshold of being a unique enough situation to accept for me? So I'm right in between there. But welcome other thoughts.
Well, I think right now we're talking, I haven't heard anything about the specific cases before us that has established standing. The conversation we're talking about is the current property condition that's not before us. That's a enforcement issue on the county's part. So I don't think we've met the threshold for standing in this case.
Yeah, you have to incredibly assert
There's
special
not-
damages.
there's not
I
special
haven't heard that
unique-
either.
yeah.
I would have to concur with Gabe. I haven't heard anything, and it is not unique. I understand it is happening. But also a lot of what we've been hearing was, on the cusp of being professional testimony from not a professional, at least not in this field. And I think that is our benchmark typically is to, but, we do have a professional here to speak on that. And as far as a timeline for him to offer some, defense or counter professional witness, I don't know about that. That's just.
Yeah, he's got to prove the standing issue or prove enough to a certain threshold to the board before we consider laying anything. So, any other thoughts?
Sir.
I was with you, Andy, on the fence back and forth. Gabe, you made a compelling statement there, and that creek runs a long ways. There's a lot of people that are impacted by this. So the uniqueness is a challenge in my mind to think that this is a unique individual situation.
It is.
Yep.
Yeah. Any other thoughts before we hear a motion on standing? All right, I'll make a motion to, yes, sir. Yeah,
Yeah, I was going to make a.
yeah, go ahead, please do.
I move that we grant standing to Mr. Fraser.
Okay. Is there a second to that motion?
Second.
Okay, is there a second? This needs a majority vote. So go ahead and do a show of hands, if you will, on yes on this, to grant standing.
Yes.
Okay, not to grant standing. Okay, that doesn't pass, so that's a positive motion that fails, so we'll go ahead and accept that. Thank you. So there's an opportunity at the end of the hearing for us to call witnesses up, and we'll be able to hear from you at that point, and then there'll be an opportunity for the applicant, if they want to address anything you bring up.
May I ask what constitutes a unique situation?
Sure. Does staff want to go over the four standing criteria for us real quick? Yeah, sure. Sure, yeah. Never. Yeah, there you go.
So reading off the variance application, it would be how an unnecessary hardship would result from the strict application of the ordinance. It shall not be necessary to demonstrate that in the absence of the variance, no reasonable use can be made of the property. How hardship results from conditions that are peculiar to the property, such as location, size, or topography. Hardships resulting from personal circumstances, as well as hardships resulting from conditions that are common to the neighborhood or the general public, may not be the basis of granting for granting a variance. How a hardship did not result from actions taken by the, this is for the variance.
That's for the variance application, yeah.
Apologies.
Yeah. You're fine.
So let me find the standing. Sorry about that, board. House special damages as the result of the proposed action that is subject of this hearing, and the damage suffered are distinct from those damages to the public at large specifically, are not distinct from those damages to the public at large, or excuse me, that is not distinct. So really, it's just damages distinct to you and not to the public at large.
Yeah, thank you.
So my question is, since we are the house, the property that has suffered the greatest from runoff from 260 Christ School Road,
In your opinion?
why that is not unique?
The-
Unique means one occurrence out of the universe, and
You have to have a situation, or your property has to be in a situation that is unique from other properties, and the creek is running adjacent or on other people's property in addition to yours in the neighborhood. And that's
our
why you're
house-
not unique. Yeah.
Our house is the one in the neighborhood that was threatened by water running entirely around the house, going into the crawl space. There is no other property that suffered that damage.
The board has no way to know that.
Pardon me?
The board has no way to know that or ascertain that.
I'm sorry, I'm going to interject here and say that the board has already voted on this matter.
Yeah, we've already voted on it, but thank you, sir. And if you want to stick around and be a witness, we'd like you to do that.
All right.
Thank you. And, yeah, but what's in here? Ms. Frazier, yeah.
And Mr. Chair, before she begins, I'd like to make just a technical observation, motion request to the board. The board just heard evidence on this exact property. I believe that the
We know,
board
yeah.
may be precluded from ruling a different way under a doctrine of claim preclusion. I will let Ms. Broughton explain claim preclusion to the board if the board wishes, but the broad strokes are that once a judicial body has made a decision on an issue, that it can't reverse, that it doesn't need to hear that again. That said, I am not in the business of limiting the speech of Ms. Frazier. I think the board should listen to her, and again, we would welcome her to ask questions of Mr. Sugg and be satisfied as to the development and the information that we're going to present in this hearing.
Thank you. And Ms. Frazier, thank you again for being here. Would you like to continue with a standing application at this time, or would you like to withdraw that and speak as a witness later on in the hearing?
I don't believe that it is necessary for me to continue with that application since.
Okay, perfect. We'd love to have you up later for the witness testimony.
Thank you.
Thanks so much. Anyone else here to start standing? Going twice, going three times? Thank you. And we'll invite the applicant to formally introduce.
And we do always have a jarring transition here between the standing phase and the presentation of the case phase. A lot of this information will look familiar to you. It was included in your staff packet, in your staff report, most of it. This is the location of the property. We're in R3 residential zoning. The current use of the land is.
Sorry,
as
Mr.
noted-
Freeman, if you're speaking on behalf of the applicant, I think you need to be sworn in. If you're not just making an argument, if you're speaking factually. on
So
behalf-
this is information that's already in the record.
Okay.
It was taken from the staff report. Let's see, this is, and well, for the benefit of what Ms. Broughton said, I'm going to move on from this. Again, I think this is within the ambit of legal argument, but let's touch base and talk about that afterwards. Let's see. I'm just going to go ahead and call up Mr. Warren Sugg as our first witness.
Please state your name and raise your right hand.
Warren Sugg.
Do you swear or affirm to tell the truth at this hearing?
I do.
Mr. Sugg, can you please introduce yourself to the board?
Hello, Board. My name is Warren Sugg. I work for Civil Design Concepts here in Asheville. Been before you before. Once again, being the civil engineer and land planner on the project, I've worked with Civil Design Concepts for 11-plus years. I've had my professional engineer's license in North Carolina, South Carolina for a few decades now, and been before this board and other boards several times.
And at this time, we would like to tender Mr. Sugg as an expert in civil engineering and development ordinance application and compliance.
Hearing no objections, so tendered.
Right. Mr. Sugg, looking at the slide that is being presented to the board, can you please give a brief overview of this project?
Absolutely. So the plan that you have in front of you is the C-101 plan. This is the existing conditions plan. From this plan, you can see Christ School Road, the North Carolina road to the north of the site. You see a gravel pattern that represents some of the area that is unpaved but is cleared. As you've mentioned, from an aerial view, you can tell that pretty much the whole site has already previously been cleared. That's outside of this project, outside of any of our engineering services, and done prior to us getting involved. But you do see the structure that's in the approximate midpoint of the site, a couple different structures, and you do see a driveway that's in a darker gray that runs from Christ School Road to the existing structure. The next plan sheet that you have is the C-201 sheet. This is the site plan for the development. The gold structures that you see with numbers 1 through 44 represent the 44 townhome units. You see a main line road that is going from Christ School down towards the T intersection, and we've had that named. That is the Laurel Crest Drive. The road that's going a little more east-west is called White Hart Hickory Drive. Those are the main access points to these 44 units. These 44 units are townhomes. Each of them have one garage space. They also have garage spaces. And then we do have the 15 shared parking spaces. About half of those are, as you first come in, on the right-hand side where you see the playground area with some benches. You also see the mail kiosk area, small dog park area, the monument sign area. As you come past those 8 or so parking spaces, you get to units 44 through 41, and that pink line represents a retaining wall. We'll see on some other pages the approximate height of that wall. If you look in other areas, to the south, you see a retaining wall. To the north, there's a retaining wall. The other things I want to point to here is the green area that's represented around the western boundary, the southern boundary, and the northeast boundary. That's the landscape buffer that we'll talk more about in a few minutes. We also have in orange the setback lines, and you can see that on the side, the front, and the rear of those property as a whole.
And Mr. Sugg, while we are looking at that landscape buffer, are you aware of a recent agreed-upon change to that buffer that was agreed to with the HOA that borders the property to the south?
I know there was conversations going on just recently, and I don't know all the specifics of that agreement, but I do know there's been conversation back and forth, and it sounds like agreement has come to that.
Okay. As you're looking at that site plan, are you able to use your mouse to articulate the southern border of the property?
Let's see, do y'all?
I don't know if it shows up.
See, if I move that, do you see anything on your side? I don't think you do. Let's see if I see anything over here. Do you see? Okay, there we go. So the landscape areas that we were talking about here is what I'm going to call the western boundary, but the
And
southern boundary.
before we get to those, let's see, let me operate the, and members of the board, this is really just me trying to be a little bit more efficient and let the board know the conditions that we agreed to with the HOA members who had requested standing, and we resolved their issues with this project by coming up with a different buffer scheme. So I'm going to highlight that for the board and then ask Mr. Sugg a question to get that into the record. I'm sorry for the awkwardness of the presentation. We just resolved this moments before the hearing.
Excuse me, Mr. Chair, does he need to be sworn in if he's going to testify on?
We've sworn him in, right? Mr. Sugg? Yeah, we have.
No, the attorney, it sounds like he's going to be,
Attorney, we don't typically swear in the attorneys.
He's not representing.
Right.
Then he doesn't need to be sworn in.
No, yeah, no.
okay.
I'm just asking questions.
Right.
All right. Mr. Sugg, is this road identified as,
That would be White Hart Hickory Drive.
thank you, sir. Is it your understanding that the agreed-upon landscape buffer will be a 15-foot buffer as explained in the county ordinance buffering requirements?
Yes.
Okay, and that it will extend on the rear lot line of the property and the side lot lines of the property up to that?
White Hart Hickory, yes.
Yes, Mr. Sugg. Is that your understanding?
That is my understanding.
Okay. Now that that is your understanding, can you explain that to the board in a better way than we just went through it there?
Yeah, so landscape buffering around edges is usually a mix of trees and shrubs to just try to buffer. I think we all experience buffering, and maybe at your own property or as you drive by other properties. It's just the landscape material that keeps you from visually seeing back and forth, or at least mitigates it to some degree. And the county has requirements for parking lots and other areas where you're unlike uses. In this case, we're actually residential against residential, so there's no technical reason to have a buffer here, but we're offering it nonetheless as a good faith and as agreed upon.
Excuse me, sir. Is that one sidewalk running alongside that Laurel Crest Drive?
There is a sidewalk on the, what I'm going to call the western edge, and it goes around these units and up to Christ School Road. So there is a sidewalk on that side, yes, sir.
But not the other side, so.
No, sir, on one side of the road.
So let me just ask this in a cleaner way to get it in the record. Is it your understanding that the applicant has agreed to install a 15-foot buffer as described in section 78-677B along the rear lot line of the property and continuing along the side lot lines of the property up to White Hart Hickory Drive? The buffer planting requirements may be adjusted to accommodate the required necessary retaining walls and stormwater control measures shown on the site plan or required by the county?
That sounds good to me.
Is it your further understanding with regards to the frontage of the property that the applicant has agreed to install a monument sign and landscaping along the frontage of the property to be maintained in perpetuity by the community association to be established? Said landscaping shall be designed in a manner that does not negatively impact utilities or sight lines for vehicles entering or exiting the property and is subject to NCDOT approval?
Yep, and we show the monument sign on the site plan and along that frontage. I agree.
Mr. Sugg, I apologize for the interruption. You can continue reviewing the site plan with the board. I believe that you had left off at buffering.
Okay. So we've hit on the main component being the 44 residential units, the driveways. We've talked about the access and the parking. I'll camp here for just a minute on the parking. There's 103 parking spaces that are proposed here. There's 44 that are in the units. There's 15 that are inside of driveways that are not encumbered by right-of-way. There's another 29 that are in driveways but are encumbered by the right-of-way. And then there's another 15 shared. So I know there was a little discussion on how many parking spaces are proposed here. So 103, so that's actually 2.3. And we can get into the technicalities of right-of-ways, but we're not encumbering the road. I'll go to the next page, which we won't stay on long, but this is just a plat plan. This shows the 44 residential lots that would be the units, and then you have the common space that would be all the other owned areas by individuals, and then certainly the right-of-ways of the roadways that we had spoken about. The next plan, and this may start to speak to some of the questions that we had earlier, we do have a sediment basin, our main sediment basin, that would be here. This would be the sediment basin that would be above ground. It would have the filters in it. It would have a drawdown and a skimmer. This would be during construction, so just during those times when it is being built and it's raw land, that would be in. There's also another sediment basin that is down here on White Hart Hickory Drive that would be for that sub-drainage area. That would be during construction. These would both be taken out of place and brought to final condition and final stormwater in just a moment, but those are in during that time. This is the plan that also shows the retaining walls that are now not pink but black on this sheet. There's 3 of them. We also have called out in the retaining wall table over here to the side, the names, the lengths, the heights. I don't believe we're going to have height concerns as mentioned on an earlier case, and these are inside of the setback, definitely in all places, and where they're not, they're definitely less than that 10 feet. You do see some proposed grading, these lines that go across the sheet. You can see a dark one here and lighter ones. Those represent what we propose as the proposed grades after we're done with construction. We have a construction entrance off of Christ School Road. We have silt fence that wraps the site. And then we have temporary diversion ditches that will help get drainage to those sediment basins during construction. Go to the next page. This is road profiles for the 2 roads, the top road being the Laurel Crest Drive. You can see some of the percentages, some of the K values, and the connection points. This is a very flat road in comparison to a lot of roads here in western North Carolina. And also below you see the White Hart Hickory Drive profile there again, trying to stick to existing conditions as best we can, but a very minor sloped road. As you go to the next page, C501, this is the stormwater sheet. This would be the final condition stormwaters. Certainly all of this has to go through detailed design and detailed review after this entitlement proceeding, but this gives the idea of where those things are going to happen. This below ground storm tech system here is the main treatment system for the site. There is also a second storm treatment system to the southern edge of the site. Those both have outlets that are keeping drainage in the natural sub-drainage areas, which is a requirement of Buncombe County stormwater. You also see some lines and boxes. These represent the inlets and storm pipes that would capture that post-development storm and take it to these storm techs.
Mr. Sugg,
Mr. Sugg, I have a question on this particular slide, and it's possibly just for educating me. Rain from the roof down gutters, where does that get discharged?
So it gets discharged into, if it's in the front of the site, it may be diverting towards the roads. If it's in the rear of the site, sometimes the side will have detailed ditch between boxes of units and behind the units. You can actually even see a ditch along this edge right here. So that downspout goes towards those inlets, which then goes to the storm techs to get captured, released.
So that runoff from the roof is also incorporated into the stormwater management
Yes, sir.
solution? Along with all the runoff from the driveways and the sidewalks?
Driveways, roads, sidewalks, rooftops, all that goes. The only thing that is untreated is there is a natural drainage path that comes through here from off property onto us, and there is a bypass pipe that I'm going to try to carefully mark, but it goes through here, through here, through here. That is actually bypass that is not being treated, but that's not any of our water.
And one other question, the calculation for the size of these collection areas takes into account all of the surfaces where the water is not penetrated into the soil,
Yes, sir.
including the roofs?
Yes, sir.
Thank you.
Mr. Allen, thank you for that question. That was a good question. And Mr. Sugg, my follow-up is, can you go into a little bit more detail and explain to the board what a storm tech system is?
Sure. So a storm tech system, and I'm going to stay careful here because we have to be careful with proprietary systems, but storm tech is a widely accepted below-ground storm treatment device. It is a system where the water comes in. It has what's called an isolator road. That's the side where if you had drink cans, oils, sediment, that it gets captured. It then goes from that isolator road to the bays where the water is actually held, and it has a bottomless part to it that has a grid of stone that tries to infiltrate that water back into your groundwater. When you have those larger storm events, larger than the design storm, then it does bypass through the system, but it still has that ability to draw down over time. So it is a below-ground system that most folks will drive by and never know exactly what it is. It has some inspection ports, it has some inlets, but it is there to not only capture the volume of water, but to draw it down and to treat it before it's released.
Does it require maintenance?
Yep, and Buncombe County has requirements for how often it has to be inspected as well.
Thank you.
I think this is the last page. You're getting close to the last page. This represents the water and sewer connectivity for the site. So we did have a water and sewer allocation or will serve letter from MSD and from City of Asheville. It shows some water line upgrades along Christ School Road. There's currently, I think, a 2-inch line there, and we're increasing it to a 6-inch line along that same alignment. And then the MSD is actually kind of right along Christ School Road. So we would have a public sanitary sewer along our roadway that we're creating, and then services to each of those individual buildings. I think that's all the different sheets. Can I answer any of the questions?
Mr. Sugg, can you? Sorry, there's a delay. Mr. Sugg, can you, when you designed this site plan, did you consider the applicable requirements of the Buncombe County Ordinance, including Division 6, which applies to special uses, Section 78-67, which is the procedure for obtaining special use permits, Section 78-66, which applies to planned unit developments level 1?
So we did, and with all of these, we always like to have an early assistance meeting with staff, talk through the project, talk through the processes, see if there's any red flags that come up there. We take great information from that in designing it, not only to code, but to staff's latest thoughts and views on it. It then gets submitted to staff, which takes it through the technical review committee. We get back comments, respond to those comments, and in the case of this, we even had a neighborhood meeting where we did the involvement that I think the board is used to seeing. So yes, we do take not only the code into question and into discussion, but also just constant coordination with the staff on the development.
Do you have a rough estimate of about how many units such as this that are in use in Buncombe County today?
I don't have a Buncombe County total of townhomes that are in use.
No, I mean this drainage, this water system, this collection system.
The stormwater?
Yeah.
Your question is how big is the storm tech system?
No, I mean, I'm guessing that this is in use in a lot of locations already.
Oh, I understand. You're asking how many places around town is a storm
Correct,
tech used?
yeah.
I don't
This
have
type, of
exact
this type.
numbers,
Yeah.
but storm tech, a below-ground storm treatment device, is probably the majority of sites
Okay.
that are new development. There are some other systems that are out there, but a little bit older times, people had a hole, a pond that things went into.
Yeah.
Our land here is very expensive, so we like to get multiple uses out of it. So in the case of this, you've got a below-ground storm system that then has the ability to have dog park, lots of other uses on top of it, and it's a better use of our land.
So it's a proven technology.
Yes, sir.
Hopefully, one more question for you.
Yes, sir.
On the site plan, you depicted two structures, and those are the only two structures that are depicted, and it's on the adjoining property. Why are those two particular structures depicted?
This plan, the existing?
No,
addition?
no, you're
This plan.
starting on that slide and through every other slide.
Oh, the two, there's two houses. Actually, I'm not sure if the more rectangular or more square one, I'm not sure if that's somebody's garage. It may be, but those are two structures that are off property of us, but are a neighbor.
But why were those two depicted? I'm just, and again, I'm going to the fact that there's a discharge, proposed stormwater discharge that's in close proximity to those two structures.
Those are the two that were, as we cut our plan sheet, those are the two that were within the view. So if we'd have zoomed out further to a different scale, you may have seen more existing structures. Those are the only two that are in that view.
So the answer is due to the proximity of them to the site, those two were included.
Yes, sir.
Yeah, I just want to ask, since the former owners of the property were cited for this erosion violation, I'm assuming, tell me if I'm wrong, that your plan for runoff and everything would resolve all that?
Our plan would take care of our development for post-construction and during construction stormwater controls.
No other questions now?
Mr. Chair, I believe that would, I'm sorry.
Anything else you're going to plan to bring up?
Mr. Chair, we do have folks here to talk about traffic and property value impacts if the board wants to hear it. I believe that most of the concerns that have been raised here today concern Mr. Suggs' testimony. So we would rest in the interest of the board's efficiency and reserve the right to call them as rebuttal witnesses if needed. But we would be happy to move on to the witness phase of the hearing at this time if that's what the board wishes.
Does the board have any questions related to property valuations surrounding or traffic? What's that?
The only one I was considering is property value, but I will concede to the majority of the board.
Anybody else have questions about those two? Want to hear from them, or you want to See if it comes up. Okay, all right. Anyone here to speak as a witness on this matter? Any witnesses here to speak? Now would be the time. And one more call. Anyone here to speak as a witness? Okay, we'll close that portion. Any closing remarks?
Mr. Chair, just briefly, I appreciate the board's time. I appreciate the board's patience with me sort of awkwardly fumbling through some of this presentation, as always, and those conditions especially. I think I tried 3 times, and I hope on the 3rd time I got the accurate version of them to the board. I will look to Mr. Brian Golden to make sure that he's okay with that.
And, Mr. Chair, I think we had sent them to Ms. Broughton to be part of the conditions. They were, as Mr. Freeman read.
Thank you. Thank you for that.
Sorry, we have, for ease of drafting the order, in hopes that we would be drafting an order, and for ease of the same, we have already sent those to your legal counsel. We, as always, whenever we come here, we appreciate this board in adding to the housing stock, and we think these are good. These townhomes are a good, they'll be great homes for people who need them. So thank you.
I think so. All right, we'll close the public hearing at this time and open it for board discussion, deliberation, and motion. Yes, sir.
Yeah, just a comment from the standpoint of being a good neighbor, and I think you mentioned it, maybe have a conversation with the Frasers and maybe go into more of the technical aspect and everything, because what was mentioned by Mr. Sugg, it sounded to me based like that it may take care of a lot of these, situations that pop up.
My thoughts are that we can't go back and reverse the clear cutting. We can't change weather patterns. Those things are going to happen. But I do think that the preventive steps that have been outlined by Mr. Sugg will be a vast improvement in the current conditions that exist out there. And we've got to trust that the engineering firm does their job and that our inspectors here in Buncombe County do their jobs. And I'm supportive of the applicant's plan.
I would agree. Having, I don't know that it's a proud distinction, but I actually put in the first underground stormwater system in this county.
Look at that.
And bore the expense of drafting the first set of documents. But that was a long time ago. So I said all that to say this. It's time tested, and I think it would be conservative to say a few hundred of them in the county at this point. I mean, and having been through the process and having the county follow behind you, that water will be much cleaner when it leaves there, when they're done, than it is today. And I hope that gives everybody some peace of mind. And of course, the volume during a storm event will also be much more controlled than it is today. So that this is a net positive, although it may not feel like it today. This is a net positive for the neighbors and the creek in general.
I felt like the testimony by Mr. Suggs is very convincing, and your comments are very helpful, too. I really think that this is the right move to put in this system and go forward with the project.
And I mean, and I guess I would also add, while it's relevant, but it is also a pretty darn expensive thing to put in the ground and make work. So it is.
That's right.
I think it'll be a net plus when it's said and done.
Wonderful. Is there a motion or other comments?
Any other comments? Mr. Chair, based on the evidence presented to this board, including the following exhibits, the petitioner's application, the submitted development plan, the GIS maps, the staff report, testimony presented at the meeting, and Amy, I'm adding conditions agreed to with the homeowners association would be an appropriate capture of all parties. I move that this board adopt the following findings of fact. 1, that this matter was properly advertised, is within the board's jurisdiction, and is right for its consideration. 2, that this application, together with the conditions proposed by staff and/or this board and agreed to by the applicant, if any, does meet the requirements for granting a special use permit contained in Buncombe County Code of Ordinances, Section 78-621, subparagraph 3.
There's been a motion on findings of fact. Is there a second?
Second.
Any motion is second. All those in favor, please say aye.
Aye.
Any opposed, nay? That motion passes.
Mr. Chair, based upon the foregoing findings of fact and for the reasons set forth therein, I move that the requested special use permit be approved and that the order approving the permit be adopted and executed as presented and as modified in this meeting.
There's been an approval motion. Is there a second? Second. All those in favor, please say aye.
Aye.
Aye. Any opposed, nay? That passes. Thank you so much. At this time, we'll hear an order on this case.
Having considered the evidence presented to this board, including the application, the submitted development plan, the GIS maps, the staff report, testimony presented, and the arguments advanced by the parties, the board hereby finds as follows. This matter was properly noticed and advertised and is within the board's jurisdiction. It's also ripe for its consideration. The applicant applied for a special use permit pursuant to the Buncombe County zoning ordinance to build a 44-unit townhome residential development. The property is located in the R3 residential zoning district. At the hearing, the applicant and any parties with standing were given the opportunity to offer oral and documentary evidence, as well as to submit questions to each other, county staff, and board members. Pursuant to the Buncombe County Code of Ordinances, the board finds as follows with regard to the special use permit. The land within the PUD will be under single ownership or managed by the applicants before final approval and/or construction or proper assurances have been provided that's such that the development can be successfully completed by the applicant. The density is consistent with the intent of the district in which it is located and conforms to that permitted in the district in which the development is located. The land uses are compatible with and do not violate the intent of the zoning district and do not disrupt the character of the community. The proposed land use meets minimum requirements for land development as follows. The minimum lot size and requirements for interior setbacks preserve the spirit and intent of this section and comply with the density requirements for the zoning district with respect to the total development plan. Proposed heights, as set forth in the application, comply with the spirit and intent of this section with respect to the total development plan. Where building heights exceed the maximum allowed by this ordinance, the board finds that unique elements of the development impose requirements for additional height that are not universal throughout the zoning district. This board finds that the minimum distance between buildings will ensure adequate air, light, privacy, and space for emergency vehicles. That the development does provide reasonable visual and acoustical privacy for all dwelling units. Fences, insulation, walks, barriers, and landscaping will be used for the protection and aesthetic enhancement of the property and the privacy of its occupants, screening of objectionable views or uses, and reduction of noise. Multi-level buildings are located in such a way as to dissipate any adverse impacts on adjoining low-rise buildings and do not invade the privacy of the occupants of such low-rise buildings. The structures located on the perimeter of the development will be set back from property lines and rights of way abutting the street in accordance with the provisions of the zoning ordinance controlling the district. This board finds that proposed parking complies with the spirit and intent of this section. As applicable, this board finds the conveyance and maintenance of open space, recreational areas, and communally owned facilities are in accordance with the applicable North Carolina general statutes, specifically the Unit Ownership Act. This board finds that the building envelopes are shown in the submitted plans and depict the maximum expanse of the proposed footprint of the structure. Pursuant to the Buncombe County zoning ordinance, satisfactory provision and arrangements have been made for the following. The proposed use will not adversely affect the health or safety of persons residing or working in the neighborhood of the proposed use. The use will not be detrimental to public welfare or injurious to property or public improvements. The use will not cause or have adverse effects on surrounding properties due to noise, vibration, odor, or glare effects. Satisfactory ingress and egress for the use of the property and proposed structures has been provided. Provision of off-street parking and loading areas where required, with particular attention to Section 78-658 of the zoning ordinance, have been arranged for. Provisions for adequate and proper utilities have been arranged for. Provision of buffering, if necessary, with reference to type, location, and dimension has been arranged for. Signs, if any, and proposed exterior lighting with reference to glare, traffic safety, economic effect, and compatibility are in harmony with properties in the district. Playgrounds, open spaces, yards, landscaping, access ways, and pedestrian ways with reference to location, size, and suitability have been arranged for. Buildings and structures with reference to size, location, and use are acceptable. Hours of operation with particular reference to protecting and maintaining the character of the neighborhood are acceptable. The following conditions are necessary to ensure that the proposed use will conform to the requirements and spirit of the Buncombe County zoning ordinance. First, a major subdivision plat must be submitted, approved, and recorded, and new pins assigned and reflected in the Buncombe County GIS prior to site plan review applications. Second, an NCDOT permit is required. Third, applicant agrees to install a 15-foot buffer as described in section 78-667B along the rear lot line of the property and continuing along side lot lines of the property up to White Hart Hickory Drive. The buffer and planting requirements may be adjusted to accommodate the required or necessary retaining walls and stormwater control measures shown on the site plan or required by county. Fourth, the applicant agrees to install a monument sign and landscaping along the frontage of the property to be maintained in perpetuity by the community association to be established. Said landscaping shall be designed in a manner that does not negatively impact utilities or sight lines for vehicles entering or exiting the property and is subject to NCDOT approval. The remainder of the conditions are standard. Based on the foregoing findings of fact, the board makes the following conclusions of law. The applicant's request for a special use permit, together with the imposition of the conditions found necessary, which are incorporated herein as if fully set forth, meets each applicable requirement of the Buncombe County zoning ordinance. Now, therefore, based on the foregoing findings of fact and conclusions of law, the Buncombe County Board of Adjustment orders as follows: that the applicant is hereby granted a special use permit to establish a planned unit development on the property as requested, subject to the conditions above, which are incorporated as if fully set forth herein. July 8th, 2026.
An order has been presented to the board. Questions, comments, or motion?
Motion to approve?
There's been a motion to approve. Is there a second?
Second.
All those in favor, please say aye.
Aye.
Aye. Any opposed, nay? That passes. Thank you very much. Congratulations again. Thank you, Mr. Freeman. Anything else from staff today? All set? Anything else from the board?